The U.S. judge overseeing Donald Trump's election interference case has agreed to limit the evidence the former president will be allowed to share from his trial, but stopped short of granting the blanket ban prosecutors had sought. U.S. District Judge Tanya Chutkan addressed concerns that Trump could release evidence on social media and cautioned that arguably ambiguous statements could be construed as intimidation or harassment of potential witnesses. She will take whatever measures are necessary to safeguard the integrity of the case. Prosecutors had sought a broad protective order barring the ex-president from sharing any details of the government's evidence publicly, claiming that Trump, who regularly takes to social media to slam officials involved in the case against him, could use the details to influence witnesses. However, Trump's defense lawyers argued that a wide-reaching order would violate his right to free speech under the First Amendment of the U.S. Constitution. Chutkan agreed with Trump's defense team on a looser version of a protective order for evidence in the case, but she largely sided with the prosecution on what sensitive materials should be protected. She later officially approved a protective order that will allow Trump to share any records that are already in the public domain or that he obtained independently. He is not, however, permitted to share other kinds of materials, such as those arising from the grand jury or items obtained through sealed search warrants. The 2020 election interference case marks the most significant of the three criminal indictments against Trump, with one expert calling it probably the most significant legal case in the nation's history. The indictment accuses Trump of pursuing unlawful means of discounting legitimate votes and subverting the election results in an attempt to scuttle Biden's 2020 victory. The legal battle over the proposed protection order had become an early flashpoint in the widely watched case. Prosecutors had proposed a protective order barring Trump and his lawyers from disclosing materials provided by the government to anyone other than people on his legal team, possible witnesses, the witnesses' lawyers, or others approved by the court. They also asked for stricter limits on sensitive materials, which would include grand jury witness testimony and materials obtained through sealed search warrants. Trump's defense lawyers wrote in court papers that the need to protect sensitive information does not require a blanket gag order over all documents produced by the government.